General.
Thank you very much, Mr. President. And may I say thank you to all senators who've contributed, and in particular to the independent senators. And at the risk of incurring the criticism of repetition, may I begin my wind-up where I began my pilot. I apologize. We entirely accept that this bill has come to this Senate, this honorable chamber, late, and we wish it could have been otherwise. We don't accept, in the cricket metaphor terms, that we have completely dropped the ball, but we take on board the very useful comments and suggestions of the honorable senators of the upper bench to be able to give the solemn assurance that we intend fully to catch the ball the next time. A number of very useful comments have been made by all of the independent senators who have spoken, and I acknowledge them all. Some I will address in particular, but I wish to say that all senators of the upper bench have made very useful comments, which I have personally found significant. And members will appreciate when we get to the committee stage that I am in the process of circulating 3 amendments. One from the wisdom of Senator Dylan Remy. One from, and I made a note when he made these utterances because it struck me as being very significant given the temper of the gentleman, and I use the word temper in the tempering sense. Senator T.A, he spoke of having to restrain his emotions when he was reading the bill between yesterday at circulation and today on the debate. And that struck me because Senator T.A, I've come to respect not only for the quality of his contributions, but the measured tones and the measured manner in which they are always delivered. It is a disposition which, to use a phrase that I like to use, which I would like to emulate when I grow up. And the second amendment that I'm circulating addresses the very legitimate criticism that he made with respect to one of the sections where the word licensee was not defined. And I will therefore be asking members in the committee stage to accept that amendment. We will deal with it at the appropriate time. And there's a third amendment which, in the schedule, folding chairs as one of the prohibited items is not spelled out, and instead folding on the mound. So we've introduced the word chairs to qualify folding. So we will be making those amendments. And I say all of that not only to accept gratefully the wisdom of the upper bench and the contributions that they've made, but also to acknowledge that, as I said in my pilot, those who have assisted me in the drafting process have worked hard, long hours, and we are not perfect, including the fact that we've come late to the Senate, And that slipping of the term chair from folding chairs was one of those things that we missed. So thank you to the honourable senators. Many different remarks were made otherwise, and I would just address a few of them without any disrespect to the fulsome remarks made by all senators. Senator Maraj spoke to the value, and it was one of the things that I too emphasize, and I'm happy to associate on this with Senator Maraj. She spoke to the value of the CARICOM single space and free movement and wants to hear more about that on the agenda. And I really do think that one of the templates that we have been given by the T20, I almost said free 20, by the T20 cricket, is that it is encouraging us to see and to understand and to put into effect the concept of free movement in the single domestic space of the Caribbean. We are working on it in larger terms in the Legal Affairs Committee, which consists of the Attorneys General. But the template that has been given to us by the T20 cricket is something that we can continue to apply, and I would hope, going to the point Senator Vera made, that we can do better the next time. I would hope that we don't, at the end of the sunset period, 30th of June 2024, simply put this away and not look at it until the next T20 comes up. We need to keep using these precedents as the templates for our own existence. Free movement within the single domestic space of the CARICOM region. So I acknowledge Senator Maraj's contribution in that regard. Senator Dylan Remy had made the point in relation to clause, as I recall, if I can find my papers, Senator Dylan Remy had made the point in relation to the clause 3, clause 2A, dangerous weapons and instrument. Well, that's one of the amendments that we are making. And the short point is that in clause 3, clause 2G, the word instrument was out of place because dangerous weapons, when you go to clause 2, says dangerous weapon means any, and then it lists the different weapons. And G instrument was not to be there. G instrument was really to be at the bottom, as we shall see in the amendment when we come there. So it would be dangerous weapons means any instrument, article, or material which can be used to maim, disfigure, etc. But we will come to that. So thank you, Senator Dylan Remy. Clause 19.2 was also addressed by Senator Dylan Remy to make the point, 19.2b, with respect to authorized person, and the point about 19.2b is when you read it fully, you appreciate from 19.2b that what that clause is speaking to is that an authorized person would be an ICC or CWI authorized person who suspects on reasonable grounds that something has been done which gives reasonable cause to suspect that an offense has been committed. That authorized person takes a photograph, but the clause does not create an illegality. It is simply that the authorized person takes the photograph to preserve the evidence of what he or she may have witnessed. That is then given to the relevant ground authorities where the event is taking place, and is to be used, as we can see at paragraph 2, clause 2, only for the purposes of identification. So it is corroboration of what was witnessed. And if at the end of the day, what was witnessed doesn't amount to something that a police officer, and this addresses Senator T.A.'s concern, if at the end of the day, what was witnessed and a photograph was taken amounts to something which a police officer can charge as a criminal offense, then that photograph will be retained for purposes of evidence in such criminal charge as may be brought. But if at the end of the day nothing comes of it, at the end of the sunset period, 7 days on the completion of CWC 2040, those photographs are destroyed. So that the two short points in there in response to Senator Dylan Remy on clause 19 is that the clause itself does not commit an offense. The offense is only when reasonable suspicion is investigated by a police officer who then lays a charge, and that charge then falls to be prosecuted. Senator Dylan Remy also made reference to clause 24 of the bill and questioned the use of other than for personal use. Would posting on social media, if we are in the Cricket World Cup, be covered by this? She questioned if she were to go to, Senator Remy were to go to Brian Lara Cricket Stadium, would she be able to post her image on social media? Well, the point is, Senator, that any activity that is not for commercial purposes is permitted. There is no prohibition against the use of images for personal use, because the language is other than for personal use. That is to say, commercial purposes. So any activity that is not for commercial purposes will be permitted under this clause as being an activity that is for personal use. And so, yes, persons can post on social media. And that takes me across to a further point that I do think bears some elaboration, and I had referred to it in my opening and very briefly, and I just want to elaborate on it a bit. The point is that there are controls that are introduced for the management of information and images in the indicia and the images, and section 24 says, no person shall, other than for personal use, broadcast, narrowcast, telecast, transmit, etc., different images and so on. But very importantly, and this goes to a concern which Senator T.A. had expressed, and whether there were provisions in this bill that are going to trespass on the freedom of expression, which is guaranteed under our Constitution. And that has been very carefully looked at, so that section 24(7) says the broadcasting, telecasting, recording, or filming of any information related to a CWC 2024 activity for the purpose of provision of information or for purposes of criticism or review is not by itself sufficient to amount to a contravention of subsection 1. And section 8, subsection 8, goes on to define the terms provision of information and criticism or review, so that the provision of information includes a reference to the reporting of news and the presentation of current affairs, and criticism or review includes a reference to criticism or review, 1, in a newspaper, magazine, or similar periodical, 2, in a broadcast, or 3, in a cinematographic film. The point there being that the bill expressly accepts and pays tribute to our fundamental right to freedom of information and the capacity, potential, and ability of our reporting media to report, to capture images, and to purvey information for the edification of the citizens of Trinidad and Tobago is preserved by section 4, subsections 7 and 8. So I just want to give the assurance that the attempt to protect the property of the CWC, IWC, images in this year of the CWC 2024 images are not intended to prohibit the ordinary provision of information, criticism, or review, which is carried daily in our national media. Another point, if I may turn next, Mr. President, with your leave. Another point which was made by Senator Dylan Remy with reference to Clause 29.3, images and indicia of CWC 2024, who is making that judgment in terms of whether these images may resemble CWC images and indicia? Who makes that judgment, and where is my recourse? Asked Senator Dr. Dylan Remy. Well, we've incorporated in the language of the bill throughout the use of the term, the legal standard of the reasonable man. And that term will be the basis on which all such judgments as are going to be made as to whether there is a violation of a provision of the bill. If it becomes law, the act will be judged by the legal standard of the reasonable man, and there is a vast array, or Senator Wade Mark might say an armada of common law, which defines what a reasonable man is and what is the standard of the reasonable man. In the United Kingdom, it's referred to as the man on the Clapham omnibus. In Trinidad and Tobago, we say the man on the priority bus route. The classic standard of reasonableness is what this bill preserves for the judgment calls that will be made by the authorized person or any other person. And if at the end of the day, in the section that deals with remedies, anybody finds that there has been a violation, either by way of defense or offense, the courts are given very specific jurisdiction under this legislation and have ample jurisdiction at common law and under the Supreme Court of Judicature Act to assess the reasonableness, the unreasonableness, the disproportionality of any activity that is undertaken by persons within the realm of authorized persons who might become overzealous. One is not about to defend persons from, that possibility, but we have a very robust judicial system in Trinidad and Tobago. We have a responsible police service, and I am very confident that the provisions that are provided for in this bill to allow the CWC 2040 to be run as efficiently and expeditiously as we hope it will be run, I am very confident that those powers conferred by this bill on those persons will not be abused and will not be allowed to be abused. Mr. President, if I might just turn to a couple other matters that were raised. Senator T.A. raised the question of immigration. He says, with reference to, I believe it was section I'll get back to the section, but the point is in the section that deals with questions of immigration which were raised by Senator T.A, does the Chief Immigration Officer have strategies in place to deal with the influx? Well, one of the things that actually occurred, and it is part of why we are, and no blame is being assigned here, everybody was doing their work through night and day. But one of the things that actually occurred in the drafting of the bill which is before this House today is there were meetings of chief immigration officers, and I said this in my winding up, of CARICOM, and they met in Antigua and Barbuda from the 11th to the 13th of March 2024 to plan strategies to deal with the provisions of this bill and to put in place a plan to deal with the influx of visitors. So the administrators of the law, including the immigration officials, have actually very uniquely been part of the drafting considerations and process so that they are fully informed by the legislation, and those who drafted the legislation are fully informed by the confidence that they have that the administrators are putting in place the measures to enable the law to be a working instrument of fairness and justice. And again, going back to the point that Senator Maraj made earlier, perhaps we need to use this precedent of CWC 2024, not put it down at the end of it, and use it as an example of how we can get the collaboration amongst different major offices and institutions across the Caribbean. That is what has been taking place since we met here in March, 8th and 9th of March, through to when this bill was approved for passage into the cabinet, into the parliament. We approved it in Legislative Review Committee last week, Friday morning, and it's come now to the parliament. There has been a concerted partnership of effort among ministries of national security, commissioners of police, chief immigration officers, and controllers of accounts to make this a working formula for success. Mr. President, just moving on, if I may. Senator T.A expressed concerns about the declarations of venue and private property that are provided for in clauses 3.1 and 3, and asked whether this would affect private property holders who are going to be affected by the powers that are being given to the CWC and ICC. And the answer to that is no, they will not be affected. This is answered in clause 3, subclause 3C, Roman 3 of the bill. Only private property with the consent of the owner may be used to stage a CWC 2024 activity. And there's a further point to be appreciated from clause 3, and that is not clause 3, I'll come back to that. There was a further point that I wanted to make to reassure Senator T.A. Clause 12, unauthorized entry. Senator T.A. was concerned, can a person be allowed to enter a Plainfield Stadium or CWC? Can any person be allowed to enter such a venue? And the language is, unless authorized by the CWI, no person shall. Clause 5.1, dealing with traffic control, whether persons will be discommoded. Well, yes, people will be discommoded, but it is a confident expectation that the regulations will be published in advance and that traffic orders which are published will be enforced by the police. In the same way, when we have the carnival and we have traffic regulations, those regulations are enforced and we live with it. So I don't expect that to be a problem. Senator T.A. pointed to clause 9.1J, who is the licensee, and that's one of the criticisms that I've taken on board. The licensee certainly needs to be defined. It's one of the things that we did not pay sufficient attention to in getting the bill drafted. Licensed user is defined, licensee is not. We will deal with that in committee stage. Clause 19, taking a photograph, if done by an authorized person, should be done in the presence of the police. Well, the point is that throughout all the venues, in any event, CCTV cameras are at all points of entry and are manned remotely by authorized persons of the CWI, but in any event are manned throughout Trinidad and Tobago right now. And one doesn't need a police presence to be standing next to all of those CCTV cameras to make them lawful and legitimate for the use and the objective that they are intended to serve. The point is that if the evidence that is captured by the use of cameras is evidence that can persuade a police officer on reasonable grounds according to law that an offense has been committed, then we fully and confidently expect that the rule of law will prevail and that the police will charge a person on sufficient evidence, and that person will be able to avail themselves of all of the remedies and rights that they have under the law if they are so charged. So we don't anticipate that that is going to allow an abuse of persons' rights. So, Mr. President, those in the main, and as I say, I don't intend to, by omission of names, not address all of the points that were made. Senator Vera made a number of very significant points, and as I understood him, and I hope that I understood him correctly, he accepts that there is an impetus and a purpose and a legitimacy about the bill that is before the Parliament, the chamber of the Senate this afternoon, for passage, but he expresses the hope, and I would dare say the confident hope, that we will use this experience to ensure that when next we have to bring such legislation to the Parliament, we will have done the job far earlier in point of time and be able to have a much more measured and controlled input into both the bill and the debate, and also to the structure that we are putting in place for the society that, and going back to Senator Maraj's point, that we want to hope will eventually lend into the structure of a CARICOM single domestic space that we can all continue to be proud to be part of. Senator Thompson-Ahi made a number of very good points, all of which I accept, but I understand them much in the same vein as Senator Vieira's points, and those are points really to point to what needs to be done for the future management of events such as this, and not to find ourselves at this late stage asking this very respectable and august chamber to pass into law a piece of legislation that we all wish we could have spent more time looking at. But the hard choice really was, and I am certain, as I stand before you today, the hard choice really was that if we had said to the CWC and the ICC when they came to us to participate, you haven't given us sufficient time, and we will pass on this opportunity, come to us in another 5 years, I am certain that we would have been told off in no uncertain terms by the members of the lower bench United National Congress for having missed a rare opportunity for Trinidad and Tobago and deprived the citizenry of an opportunity to participate in that lovely game of cricket. So, Mr. President, without wishing to belabor the point, I have said it once, I have said it twice, and I say it a third time. My apologies. We can do it better the next time. And with that, Mr. President, I beg to.